Hi, and welcome to California Virtual Estate Planners online estate planning legal services website. My name is Ani Papirian, and I am an estate planning attorney with California Virtual Estate Planners, or CVEP for short. This is an informational video where I'm going to provide a brief explanation of some of the differences between two primary estate planning devices, a revocable living trust and a will. Please consult an attorney for your specific circumstances, and nothing contained here shall be considered creation of an attorney-client relationship, nor provision of advice or legal counseling as defined under the law. This video is informational in nature and meant to provide basic information to be used in conjunction with formal retained representation. Now, the distinction between a will and a revocable living trust is important. They play different roles and suit differing needs. At our firm's website, a visitor to the site must at the outset purchase one of CVEP's packages, which includes a revocable living trust or a will. This must be done before the visitor is able to schedule their first conference with one of CVEP's estate planning attorneys. However, during the conference, the visitor may change their estate plan package once their circumstances are better identified. Let me begin the discussion with a question. Is it possible to transfer your assets to your chosen heirs by some means other than a revocable living trust or a will? The answer is yes, but there are limited assets or methods for that to happen. The most important examples include an IRA or the proceeds of a life insurance policy, both of which are transferred on death by means of a beneficiary designation. Also, personal bank accounts can be transferred to your beneficiaries on your death by means of a pay-on-death designation that the account owner has signed at the bank. In reality, most people have a larger part of their wealth tied up in real estate, their personal residence, and in other types of investments, such as stocks and bonds. In short, most people who have accumulated wealth need a revocable living trust or a will to be assured that they have a legal mechanism in place to transfer all of their assets upon their death to their chosen beneficiaries. Yet, there are significant differences between a revocable living trust and a will. In case you did not know, the state of California has already decided who will receive its residents' assets after death, should you fail to do that for yourself. When someone dies without a trust or a will in California, this is called dying intestate. So their estate passes to heirs determined by the intestacy laws found in California's probate code. Dying intestate may mean that the decedent's estate will pass to persons that the decedent might not have chosen as his or her beneficiaries. Further, to settle the estate of a decedent who died intestate usually requires a legal proceeding in the probate court. Oftentimes, people will focus primarily on the costs required for having a will or a trust prepared by an attorney in selecting between the two. If cost is the only criteria used in making the selection, then a will is the likely choice. Normally, the preparation of a will requires less attorney time because it is a simpler and shorter document, and therefore will be less expensive than a revocable living trust at the outset. Yet there are quite a number of other things one should consider in deciding between a trust and a will as one's primary estate planning device. For most married couples and for most people who own their own home or real estate in California or have assets with a net value behind a threshold amount of approximately $150,000 or more in value, making a revocable living trust is the preferable estate planning device. Let's detail the considerations. The terms of a will only become legally effective upon the death of the maker of the will and the admission of the will in a public probate court proceeding. Thus, The additional cost of a probate down the road should be considered when making the choice between a will and a revocable living trust. For smaller estates, a simple will is adequate to transfer one's assets upon death to chosen beneficiaries, so it is effective after the death of the creator. Probate is a formal court procedure under which the assets of the estate of a decedent are determined. The debts and taxes, if any, of their estate are paid, and the remaining assets of the estate are then distributed in accordance with the terms of the decedent's will. The costs associated with probate include statutory attorney's fees, court fees, and other fees as deemed appropriate. The statutory attorney's fees for the probate of an estate in California, valued at $500,000, may be over $10,000. Most people who own real property in California are likely to have an estate valued at least at $500,000 or much greater. So a married couple in California doing their estate planning with wills who own a modest house and some other assets totaling $500,000 or more in value could reasonably expect that the two separate probate court proceedings, one at the death of each spouse, will result in increased fees. As you can see, the cost to the estate after death for a married couple in California to do their estate planning with a will can be expensive. Now let's talk about trusts. There are many features of a revocable living trust that makes it vastly more attractive to most people doing their estate planning. Estate planning is as much about planning for the care, maintenance, and support of oneself and one's spouse during your lifetimes, as it is about distribution of one's assets to your chosen beneficiaries upon death. Consider an event where either you or your spouse becomes physically or mentally incapacitated. What do you do then? What if you and your spouse were to die prematurely in an accident of some kind? Who will take care of your affairs, handle your assets, provide care, support, and education for your minor children? A significant benefit of a revocable living trust is that immediately upon creation and funding, it begins to provide a mechanism and instructions for the care and support of the trust makers. Should either of them become mentally or physically incapacitated, by nomination of successor trustees to act in their place and for their benefit and that of the beneficiaries, such as minor children. The typical trust is one where trust property is managed for the care, support, and maintenance of both spouses during their lifetimes, and for the care, support, and maintenance of the surviving spouse upon the death of the first spouse. In the event a spouse becomes physically or mentally incapacitated, the trust provisions must specify that the non-incapacitated spouse continues to serve as the sole trustee and manager of the trust property during their lifetime. The trust will name beneficiaries who are to receive the remaining trust property upon the death of the surviving spouse, or as otherwise preferred. The trust will also name an alternative trustee to serve in the event both spouses become incapacitated and to distribute the trust property upon the death of the surviving spouse. Usually, probate court proceedings are unnecessary upon the deaths of either of these spouses with a revocable living trust. At that point, the successor trustee that is named in said document would step up to continue directing the management and distribution of the trust property, income, and debts as the trust dictates. In summary, depending on your particular situation, a will may be best suited as an estate plan, but for most people, a revocable living trust offers more flexibility. To obtain specific advice and obtain representation, please contact CVEP. Go on our website, make your appointment to determine which mechanism best suits your needs. Thank you.